Thank you very much. If I could just remind all the panelists and speakers who have now been elevated to the panelists to put your microphones on mute, please. And also, as Rachel has said, to make sure you have the correct language. If you're unclear what that is, at the bottom of the screen, there's a little globe on the right-hand side, and within that you can select the appropriate language. For those needing Arabic translation, that's the Japanese channel at the moment. Yeah. And the rest are all self-explanatory. So welcome to the 4th International Conference on Access to Legal Aid in Criminal Justice Systems, the ILAC 2020. Please note that this webinar is being recorded and may be shared on social media. Given that there are many of us joining today from around the world, we invite you to use the chat function to add comments and share experiences. Please introduce yourself as you write in the chat. We also have a Q&A feature, so please submit any questions you might have there. We have lots of helpers that will assist in identifying certain questions, and then we may come back to you later during the question and answer period and call on you to ask questions. By default, attendees are on mute to ensure a smooth webinar without background noise or distractions, and the organizers may unmute individuals as we bring you into the discussion. And lastly, just to mention that the event today is hosted virtually by the Public Defender's Office of the State of Rio de Janeiro, together with the International Legal Foundation, the Open Society Justice Initiative, the United Nations Development Program, and the United Nations Office on Drugs and Crime, or UNODC, in collaboration with the government of the State of Rio de Janeiro, the National College of General Public Defenders of Brazil, the Public Defender's Office of the Union, and the National Association of Public Defenders of Brazil. So thank you all for joining today. As we've been learning from the previous sessions, we tend to go over a little bit. So as also a demonstration of courtesy to all of our participants, but also to put all the speakers on warning, I will be interrupting you just briefly at 6 minutes to let you know that you have 1 minute left. And I do beg of you all to please wrap up as soon as possible, because we certainly would like to have some interaction between all of those people attending and all of the panelists. So with no further ado, I will just jump right into it and introduce the first panelist that we have today, which is the Deputy Minister of Justice of Ukraine, Ms. Valeria Kolomets. And she will be speaking in English and also addressing some of the issues related to legal aid service in Ukraine and the role of digitalization of the legal aid system in view of the COVID-19 pandemic, and also a bit on the pro bono mediation services in Ukraine. The Deputy Minister, the floor is yours.
Thank you, Chris. Thank you all the participants of this event, dear friends and dear guests. I'm very glad to see you and hear you today. It is a great pleasure to welcome you all at this noble event, and I like to characterize the current year as the year of change for our legal aid system in Ukraine. The change were not sudden, as they are a result of the groundwork laid down last year. And now we can see the real progress at same extent in view of the worldwide COVID-19 pandemic. One of the major challenges for any legal aid system is the logistical one, like you know. to ensure that vulnerable population can easily and effectively access the legal aid service all over the country. Legal Aid Ukraine managed to largely overcome this challenge by opening the maintaining more than 500 offices in large city of Ukraine. Each city serves as administrative center so that an office or even several would operate as close to the target population as possible. A population of small village and town could easily access them using public transport. From these offices, mobile consulting teams cover even a more remote location and limited mobility population. However, due to the pandemic, the intercity public transportation were stopped, like you know, because I think that you have the same problem in your countries. And legal aid offices become virtually incasable from outside the localities of their immediate location. Most of our clients are the indigent and cannot afford to hire private transport, especially on the regular basis. Of course, Legal Aid Ukraine has a contact center, but there are a lot of issues that could not be solved by phone. So we have boosted digitalization of legal aid service. And now we see that it very good for our clients, especially when we have this challenge named by the pandemic COVID-19. And when I told you about digitalization, I talking not about just emailing stuff. It will be too disorganized and hard to operate on a large scale that we process. A whole system of digital advice and legal information with applicants being accepted through popular messengers, aggregate, and a single center help desk. Then the system was disseminated among our attorneys to provide a comprehensive consultation through the most comfortable for the client means of communication. Moreover, through our specialist app, which was launched this year, one may even fight for representation. I think you agree that the role of a legal aid system cannot be limited by providing legal advice and representation, as they may be not the most effective way to comprehensively solve the problem of a client. This year we managed to bring it to a whole new level. Now Legal Aid Ukraine helps people access pro bono mediation service. Why we choose mediation and start work with this? Because mediation is faster than litigation, especially in the reality of overloaded courts of Ukraine. Second one, that this is cheaper than litigation. No need for a legal aid lawyers. And the most important, mediation is more effective than litigation. A court decision may provide compensation, but it will not remove the dissatisfaction and conflict that lie in the core of most conflicts. And mediation, like we see, resolve them all. And legal aid staff is now especially trained to detect cases that may be mediated. Legal aid offices keep close close tie with our pro bono mediators and volunteers in these regions. If everything goes well, in future, the Ministry of Justice may even ensure that we start contracting mediators, just as we contract lawyers now. While currently it is limited to civil cases, we also hope to push for administrative mediation, as a huge chunk to legal aid cases concerns state and municipal bodies. Another important novel to Ukraine is...
1 minute, Madam Minister, sorry.
Thank you, I just finished. Another important novel to Ukraine is Restorative Justice, that is being pushed by none other than Legal Aid Ukraine. Together with this UNICEF, USAID, Judiciary and Prosecution, we implement the concept never applied before in our country. Mediation through specially trained legal aid lawyers between minors who performed an office and the aggrieved, resolving the core of the conflict and allowing first-time minor offenders to avoid criminal representable by making peace and resocialization. And we think that it's very important to the child who start work with our mediation and our lawyers, and for their future, and for the future of our judicial system. Thank you.
Thank you so much, Madam Minister. Our next speaker will be speaking in English, Ms. Ilse Tralmaka, who is a legal aid policy officer at Fair Trials. And she will be discussing a couple of key features of remote hearings, such as effective participation and access to a lawyer before and during a trial. The floor is yours.
Thank you. And thank you to the organizers for the opportunity to address you today on the important issue of remote justice. Fair Trials has been monitoring how justice systems responded to the public health restrictions since the beginning of the global pandemic. And one of the areas we have been focusing on is the remote hearings and the effective use of defense rights during those hearings. I was invited today to speak about effects of remote hearings on vulnerable defendants. And let me just start with a story from a lawyer representing a defendant in a remote parole hearing. His client suffers from a long-term mental illness, and he appeared in the hearing on video. He was alone in a room in the office. So what I will tell you now is largely a quote. For his hearing, defendant was sat on his own in a room in the prison while 7 or 8 faces appeared and disappeared on the screen. Some of them were voices without faces. Sometimes a person appeared on the screen and then disappeared. Someone else made a noise and the main screen he could see showed them instead. Some people chose to turn off their video so they can't be seen anymore during the hearing. There may be a good reason for turning off the video, but a bit disconcerting for someone who might wonder where they've gone and then find out that they've been there all the time. There's invariably someone who sounds like they are talking through a sound distortion device or doing an impression of a frog. This would be funny if they were not giving important evidence which can affect the decision whether someone remains in prison or not. Then there is the person who forgets that they are on a mute and have to remember what they've said after a few minutes of detailed answer which no one could hear. This defendant had been waiting for 18 months for a hearing, and the last 5 months during the pandemic, he has been locked up for over 23 hours a day without any visitors. So that's the end of the largely quotes. So what conclusion can we draw from these experiences? After following a rapid introduction of remote hearings and remote technology to criminal trials over past few months, the main conclusion that I could draw from this is that remote participation is not the same as being physically present in the courtroom. Appearing through screen is not a form of presence. It's a restriction of the right to be present in a way that is meaningful and that is effective. It goes for many aspects of the hearing, and I will briefly just mention 2. First one is the basic right to understand the proceedings. Without understanding, there is no way a person can influence the trial in any meaningful way. Research suggests that when appearing on the screen from a remote location, defendants feel more isolated, disengaged. They struggle to understand what is happening in their own criminal trial. UK Equality and Human Rights Commission's inquiry this April concluded that for vulnerable dependents, especially those with psychosocial disability, these effects are even more prominent. The second aspect that I will talk about is access to lawyer. Remote technology, especially if coupled with social distancing, severely restricts access to lawyer. I would argue that there needs to be physical access to a lawyer. Meaning, meeting with a lawyer is not just a procedural right for defendants. It has critical impact on defendants' ability to exercise their rights and to prevent violations of their rights in the future. During the pandemic, lawyers were not able to meet their clients in person before the hearings to check on them and to see whether they have received all the information they need, and also whether the conditions of detention are appropriate. For vulnerable defendants, this also means checking whether they have been informed in a manner and in a language that is appropriate for what they need. Meeting defendants in person and having enough time is especially important for people who are vulnerable, for defendants who are vulnerable. One of the key issues that will have decisive effect on how vulnerable defendants experience, what the vulnerable defendants experience in criminal proceedings is whether their vulnerability is detected at the early stages or not. It is so much more difficult for lawyers and also for the judges to identify a person's needs through the screen. But if defendants' vulnerability is not detected, their needs will not be addressed. And this assessment should also mean determining the fact whether hearings are suitable for this particular defendant or not. A study from the UK carried out already before the pandemic in 2017 suggests that defendants in remote proceedings are underrepresented more than they are in traditional hearings. I think this is one of the aspects that needs to have special attention. Remote hearings are much more difficult to navigate, so we need to pay extra attention to make sure that people have access to a defense lawyer. This could also mean reviewing the existing legal aid schemes and to expand them to make sure that everyone who needs a lawyer has a lawyer. I see that my time
yes,
is going to interrupt me in a couple of seconds, so I will just conclude with a final thought. Remote hearings have been praised as the cheap and the quick solution to overburdened justice systems. But what we need to talk about when we introducing technology to criminal proceedings, quick and cheap should not be the yardsticks to measure the success. What we need to ask instead is whether technology advances rights, whether it does make a criminal trial fairer and not just quicker. At the moment, we do not have enough data to say that it does. In fact, we have enough data to say that we need to be cautious. And this means that before we do talk about bringing trials online permanently, we need to do much more homework, detailing defendants' experiences, impact on rights, and on trial outcomes. I will stop here and thank you for your attention. I'm looking forward to the Q&A. I can also share a link to the more detailed report on remote hearings and other aspects that were impacted during the pandemic. Thank you.
Thank you so much, Ms. Tralmaka. We'll move right on to the next speaker, which is Ms. Chinelo Uchendo, who is a lawyer and national coordinator of the Legal Advocacy and Response to Drugs Initiative in Nigeria. She will be discussing the plight of detainees and the justice delivery system of Nigeria, obviously with the special impact of COVID on the dispensation of justice. Ms. Uchendo, the floor is yours.
Okay. Hello, everybody. Nice to be on this panel discussion, and thanks to the organizers. Ours is, I belong to a network of pro bono lawyers called the Legal Advocacy Response to Drug Initiative, LADI for short. LADI is a network of pro bono lawyers mapped by the United Nations Office on Drug and Crime under its response to drug and related organized crime projects, funded by the European Union to assist indigent drug arrestees, a group of vulnerable persons who are usually unattended to, in the sense that it's presumed, they are presumed to have access to legal representation in terms of being properly, having enough financial float. But we found out in the course of our work that this is not the case, as most of them are actually very indigent, and quite a good number of them are victims of circumstance who have either one drug planted on them or the other, you know, and some others drug users who are, you know, being victimized on basis of their use of drug. So in the course of our work, we've interacted with many of these inmates, and as well as some other inmates that have come in conflict with the law. So my discussion will be based on the impact this COVID-19 has had in our work. Before now, my country, Nigeria, suffers a lot of prison congestion issues, and which was part of the idea behind creating legal aid networks, so that lawyers, inmates who don't have financial capacity to hire a lawyer would be able to get one for free. And we've been assisting, my network is comprised of 121 lawyers from all states of the Federation in my country, Nigeria. So we go to different correctional service centers and facilities to fish out these indigent persons and to grant them timely intervention. Ever since COVID-19 started, all cases were put on hold. Many inmates and suspects that are in detention centers could not be sent to court. So there was an abuse of their human rights because they were kept unduly long in detention centers and, you know, and in the police stations of different sorts. And we know that in the police stations set up in Nigeria, or be it the NDLEA detention center, they are not particularly designed to hold people for long. They are not. It's supposed to be, and then ideally in the Nigerian police setup, within 48 hours, you should charge someone to court. You know, but for some reason, with the COVID-19, this is not happening. Courts are not sitting. Matters slated for hearings are being adjourned. Only interlocutory applications have been heard, and it's largely affected the rights of these inmates to speedy access to justice. And for those that are already in the prison, now correctional service facilities, they could not go out to court either. And there was just like a complete stop of activities for everybody, and it caused a lot of psychological trauma for some of our clients in the prison, because they feel a lot relieved each time they are being sent to courts. Each time they go out to courts, it gives them a bit of hope that someday their trial process will come to an end. So with all this, we had so much delay. Even for the with the COVID-19 lockdowns, some facilities of NDLEA where drug testing, like the drug testing units of most stations, were not working. So no trial process could be efficiently handled. So we saw all this happening, and even lawyers were not even permitted to come visit the inmates. Usually, having worked with the prisons for a very long time, we've come to experience that each time the inmates get to interface with their lawyers, it gives some form of psychological relief. They find someone to abandon to, they find someone to discuss their shared concerns and legal problems. And so all this were not happening during COVID-19. We were all just, and then my country is such that the ICT unit is not properly functioning. So we are hoping, but that the digital process of our court proceedings will improve. Though they try to make some remotes online, but it's some matters heard online, but it was just to deliver judgment, and it wasn't very efficiently handled. So these are the challenges we saw happening, and on a good day, the system, the correctional service centers and the detention facilities have challenges with coping with the health needs of the inmates. So with COVID, there was the fear that if new inmates were received into the facility, there would be mass epidemic and pandemic in the system. So even the prison, now correctional service centers, stopped receiving new inmates into the centers. So with them refusing to receive new inmates during the pandemic, during the lockdown period, it made the police station and other detention facilities highly congested. So if there was a COVID spread, it will really go around there faster than one could anticipate. So the COVID-19 brought us to the realization and need to be prepared and to further enhance our justice delivery system. And we are glad there are men and women, lawyers coming around to do this, to show solidarity and support. And we're also glad that there are development partners putting in efforts and resources to help to promote the efficient administration of justice in the Nigerian sector. And we are also glad there are networks of the pro bono lawyers coming up in different categories, because being an individual pro bono lawyer can be quite demanding, especially for most of us that were just doing it on individual capacities. We're not really registered as an NGO. We were just carrying on with the work on a charity basis, so to speak. But coming into contact with one another to form a network makes the burden shared and makes a flow of energy, creates a good synergy between each person. So we are glad that the response to drug team talked about. We are glad the response to drug team talked about creating this network of pro bono lawyers to assist indigent drug arrestees, and it's actually the very first in the country. And we hope this initiative gets replicated in all other states and nations of the world. Thank you very much for having me.
Thank you so much. Apologies for interrupting your train of thought there. So we'll move right on to the next speaker, who is Mr. Andanfar Kamanji, who is the country director for the International Legal Foundation in the West Bank. He will be speaking in Arabic for our translators. And he will be discussing providing legal aid to guarantee equality between citizens, to ensure that financial poverty is not an obstacle to achieving and accessing justice. Mr. Kamanji, if you'd like to start.
مرحبا. بتوقع في presentation PowerPoint صحيح. سأتحدث معكم اليوم في اللغة العربية. اسمي غضنفر كمنجي، المدير الإقليمي في المؤسسة القانونية الدولية في فلسطين. اليوم أنا سعيد جدا بتمثيلي للمؤسسة القانونية الدولية في هذا المؤتمر الدولي الرابع للمساعدة القانونية، إضافة لوجودي بجانب العديد من الخبرات الدولية والتي تفتح المجال لتبادل الخبرات والمعلومات. سأتحدث في هذه الجلسة عن طبيعة عمل المؤسسة القانونية الدولية من خلال التمثيل الشامل للأطفال، بالإضافة إلى عملها أثناء فترة كورونا والخطط والأفكار المستقبلية التي نسعى لتحقيقها. الشريحة الثانية. المؤسسة القانونية الدولية في فلسطين تؤمن بأهمية تقديم المساعدة القانونية كحق من حقوق الإنسان، وتعمل من أجل أن لا يكون العوز حائلاً دون الوصول إلى أي شخص إلى العدالة، كما وتسعى من خلال نشاطاتها إلى الدفع باتجاه تبني الحكومة في دولة فلسطين لنظام مساعدة قانونية مستدام. الشريحة الثالثة. وحيث أن الهدف إنساني لكل المجتمعين في هذا المؤتمر، أود أن أظهر لكم كيف كان للإنسان الأثر في تطور عملنا. أثناء عملنا في تقديم المساعدة القانونية في فلسطين منذ عام 2010 توكلت ILAC للعديد من المتهمين المعوزين، وكان منهم ذلك الطفل الذي كان من الممكن أن يقضي فترة طويلة من حياته داخل مراكز الاحتجاز، إلا أنه ومن خلال تقديم تمثيل قانوني ذو جودة ووفق معايير محددة استطعنا أن نحصل له على حكم مخفف. ومع ذلك هذا الطفل من خلال تواصلنا المستمر معه أعطانا ذلك الشعور بأن القضية عنده لا تقف عند الحد على حصول على حكم مخفف. على العكس تماما، أبدى هذا الطفل لنا بأن الطفل إنسان لديه حياة ومستقبل وحلم وأمل، وهو بحاجة فقط لفرصة حتى يستطيع أن يحقق حلمه. قوة هذا الحلم لدى هذا الطفل دفعتنا بأن نفكر بأن الأطفال بحاجة لبرنامج معين يضمن لهم أفضل النتائج الحياتية والقانونية، ويبعدهم عن معاناة نظام العدالة بما قد تخلفه من آثار سلبية وصدمات على حياة هذا الطفل. ومن هنا بدأت فكرة برنامج التنمية الإيجابية للأطفال لدينا، والتي تنطوي على أن نقدم لهم التمثيل الشامل. الشريحة التالية. في الحقيقة وحتى نبني هذا البرنامج بشكل مهني وواضح وحتى نحقق نتائج عملية، كان لابد من أن نضع خطط بحيث نقوم باستضافة خبراء دوليين يقوموا بتزويدنا بتدريبات متخصصة حول هذا الشأن وهذا الموضوع، بالإضافة إلى عقد تدريبات داخلية وورشات عمل وطاولات مستديرة مع أطراف العدالة، وذلك حتى نتمكن من نقل أهمية فكرة التمثيل الشامل للأطفال لكافة أطراف العدالة والعاملين في هذا الشأن، وهو فعلا ما بدأ الآن يجني ثماره من خلال عمل المؤسسة القانونية الدولية مع أطراف العدالة. الشريحة التالية. لم نتوقف عند هذا الحد من العمل، وإنما ومن خلال البحث والتدريبات ظهرت أهمية التمثيل الشامل لليافعين لأعمار تصل لحد 25 سنة، بالإضافة إلى فئات أخرى تعتبر من قبيل الفئات الهشة أو المهمشة مثل النساء وذوي الإعاقة، حيث ظهر أن 90% من الموكلين الذين نقدم لهم خدمات قانونية ومساعدة قانونية تقل أعمارهم عن 25 عام. وعليه بدأنا بعقد تفاهمات مع كافة الجهات الرسمية والغير حكومية لتطبيق فكرة تقديم المساعدة القانونية من خلال التمثيل الشامل للفئات المهمشة. الشريحة التالية. في الحقيقة خلال عملنا طوال السنوات العشر الماضية ظهرت أهمية المساعدة القانونية والتمثيل الشامل في إيصال المواطنين للعدالة بشكل متساوي ودون إغفال أي أحد، إلا أن هذه الأهمية تضاعفت في ظل مواجهة جائحة كورونا، حيث أنه بمجرد إعلان الطوارئ في دولة فلسطين سعت المؤسسة القانونية الدولية إلى مساعدة من هم خلف القضبان ولا يستطيع ذويهم الوصول إليهم أو حتى محاميهم، وذلك من خلال التواصل مع المحتجزين أنفسهم أو مع ذويهم أو حتى مع المحامين الذين لا يستطيعون الوصول إلى موكليهم. الشريحة التالية. كما وقمنا بالتعاون مع محامين خاصين آخرين بإنشاء غرفة طوارئ تسعى هذه الغرفة لحماية حقوق الموقوفين وإخلاء سبيلهم بالسرعة الممكنة. وعلى صعيد آخر أيضا بادرت المؤسسة القانونية بكتابة أوراق موقف بحيث تخاطب أطراف العدالة، والتي تحفز أوراق الموقف هذه تحفز على عدم اللجوء إلى التوقيف إلا كملاذ أخير. الشريحة الأخرى التالية. إن ما تقدم من أفكار وبرامج في عرض هذا قد يبدو للوهلة الأولى مستحيل، إلا أن قوة الحلم للطفل الذي كان بالفعل ملهم لنا لإنشاء برنامج التنمية الإيجابية للأطفال جعل من تحقيق ذلك ممكنا. اليوم هذا الطفل أصبح بالغا ويدير مشروعه الصغير ويساعد أهله ويعيل أهله، وأتمنى أن يكون بيننا في الأعوام القادمة ليروي لنا ولكم قصته بنفسه. الشريحة الأخرى: كل ما يلزمنا حتى نحقق ذلك الحلم هو الإرادة والتعاون من قبل
One minute, sir.
Okay, almost done. Thank you. Okay. كل ما يلزمنا لتحقيق هذا الحلم هو الإرادة والتعاون من قبل مؤسسات المجتمع المدني وأطراف العدالة بالإضافة لأي جهة داعمة أخرى حتى نصنع مستقبل وعدالة أفضل. شكرا جزيلا لكم وشكرا على المعلومات الرائعة اللي شاركتونا فيها. شكرا مستر كريس.
Thank you, Mr. Kamanchi. We'll move right on to the next panelist, which is Ms. Nadia Karine. She is from the Association the Association of Central African Women Jurists, and she will be speaking about 9 legal aid clinics that the Women Jurists NGO manage, but also in the context of the conflict and fragility of the Central African Republic. So, Ms. Pitu, the floor is yours. Can you unmute your microphone, madam? Please go ahead.
Vous m'écoutez? Allô?
Yes, we can hear you. Please carry on. Yes. No, we can't. Ms. Patu, can you try speaking so we can see if we can get the translation going for you?
Vous m'écoutez? Bonjour.
Very good. Yes, please carry on.
Oui, bonjour. Je suis formelle Poutou Nadia Karine, la présidente exécutive de l'Association des femmes juristes de Centrafrique. Déjà, la République centrafricaine, située au cœur de l'Afrique, est un pays qui a connu une succession de conflits armés entre les forces gouvernementales et les groupes armés, voire entre les groupes armés eux-mêmes. Et cela a eu des conséquences néfastes sur la population, surtout à travers la disparité géographique et l'inégalité du genre. Il y a aussi les violations continues des droits de l'homme qui constituent une menace pour la paix et la justice en République centrafricaine. Et comme je l'ai dit tantôt, c'est beaucoup plus la population civile qui demeure les principales victimes de violences. Avec tout ce qui s'est passé en République centrafricaine, le système juridique centrafricain est paralysé et que dans certaines villes de la RCA, il y a un problème d'opérationnalisation, de fonctionnement de nos systèmes juridiques. Et par rapport à ça, il y a les organisations de la société civile qui œuvrent pour la promotion et la défense des droits de l'homme tout en favorisant l'accès à la justice. Avec l'appui de la communauté internationale, ont aidé le gouvernement centrafricain pour pallier à ces dysfonctionnements. S'ajoutent aussi les ONG, surtout les ONG internationales qui interviennent dans le domaine et qui sont appuyées par les ONG nationales comme notre organisation, qui est une organisation promotion des droits de l'homme sur les femmes et depuis le 19 juin 1992 a pour objectif de favoriser l'accès à la justice de la population. Vous savez très bien, comme je l'ai dit aussi haut, que tout ce qui s'est passé en République centrafricaine a des conséquences néfastes, surtout pour l'accès à la justice. Et pour favoriser l'accès à la justice et lutter contre l'impunité, nous avons eu à être appuyés financièrement par les systèmes des Nations Unies, à savoir le PNUD qui est notre partenaire privilégié et qui nous a appuyés dans l'opérationnalisation des cliniques juridiques pour favoriser l'aide légale. Et avec ça, nous avons lancé 9 cliniques juridiques dans 9 villes de la République centrafricaine. Nous avons 2 services. Il y a le service fisco-social qui est là. Vous savez très bien que avec toutes ces violences, des fois, les victimes sont abattues moralement. Et le service fisco-social, qui est la porte d'entrée, est là pour accueillir les victimes, évaluer leurs besoins et après les orienter vers les services de prise en charge. Et il y a le service juridique et judiciaire qui est géré par les juristes qui sont là pour accompagner ces victimes, les écouter, les accompagner en leur donnant des conseils juridiques et aussi en les aidant à rédiger des plaintes pour saisir la justice. Et aussi, ces juristes sont là comme intermédiaires entre les victimes et les avocats. Tout cela est gratuit. Ce sont des services qui sont gratuits que nous offrons à la population. Tout simplement pour lutter contre l'impunité. Vous savez très bien que la plupart de la population ne maîtrise pas leurs droits et ne maîtrise pas la procédure. Mais c'est à travers ces cliniques juridiques que nous avons eu à sensibiliser la population. Et pour cela, comme je l'ai dit, le gouvernement pour respecter ses engagements, a appuyé, a promulgué une loi sur l'aide légale en date du 14 janvier 2020, la loi 20-005 portant organisation de l'aide légale en République centrafricaine. Tout cela, c'est pour favoriser l'accès à la justice de la population et lutter contre l'impunité. Et toujours à travers ces cliniques juridiques, nous avons eu à enregistrer pour la période de mars 2020 à août 2020, nous avons eu à enregistrer 1608 cas de violences basées sur le genre et autres cas de violation de droits communs que les cliniques juridiques ont eu à assister. Et parmi ces cas-là, il y a eu 1173 cas. Pardon? Allô? Vous m'écoutez?
One minute, madam.
Allô? La traduction française? ces cliniques juridiques ont permis à la population d'avoir accès à la justice. Et pour cela, comme je l'ai dit, sur les 1608 cas qui ont été enregistrés, il y a eu 184 dossiers qui ont été déposés au niveau de nos juridictions. Donc, c'est pour vous dire que à travers nos structures de prise en charge qui sont les cliniques juridiques, nous avons eu à favoriser l'accès à la justice de la population tout en mettant en œuvre la loi portant organisation de l'aide légale en République centrafricaine. Je vous remercie.
Thank you so much. Apologies for interrupting. Next, I'm going to move to a bit of an additional speaker who wanted to make an intervention, who will be speaking in English, Mr. Clifford Masiska. If the technical people can find him and elevate him to allow him to speak, I would appreciate that. Mr. Masiska has been working, well, he's the founding director of PAS Malawi and has been instrumental in establishing paralegal assistance services in other countries, including Benin, Kenya, Uganda, Sierra Leone, Niger, Libya, Sudan, and Bangladesh. Mr. Masiska, are you there? The floor is yours.
Hello. Thank you for having me. Basically, I want to start by making it very clear that access to justice is beyond legal representations. In Malawi, we have found that non-lawyers who are paralegals have been very instrumental in making sure that they assist to reduce the number of prisoners. Basically, what the paralegals have done is they have come up with a camp court. This is an ordinary court that sits in prison to screen remand population. What happens really is that the paralegals go to prison, provide legal empowerment. Thereafter, so many prisoners realize that they have an issue, or hence they have to talk to the judge or a magistrate. In so doing, the paralegals prepare a list of all people who would benefit from interacting with the judge. On that list, the paralegals consider those that have overstayed in prison, those that are illegally detained, those that were granted bail but they could not post a surety, and those who are vulnerable, women, or those who are terminally ill. So once that list is prepared and shared with the prosecutors, then on the day of the camp court, the prisoners themselves, they talk to the judge or a magistrate directly without a lawyer. Once the discussions with the judge or the magistrate has been successful, the court may either release that accused person on bail, or the court may discharge him or her, or indeed the court may vary the bail condition that it imposed earlier on. That's why he couldn't leave the prison. The advantages of having camp courts are many. One of them is, as we are now grappling with COVID-19 pandemic, the camp courts help us to reduce, prison congestion. The camp courts, reduce tension in prison because prisoners are assured that, the criminal justice system is taking care of them. And then, the judges, when they go to prison, that gives them an idea how poor conditions are in prison, so that, next time when they convict somebody, before they sentence him, they have to say, okay, well, can I really go for a sentence of imprisonment or any other, sentence? Thank you so much. That because of time, I don't have to waste your time. I have my PowerPoint, which I will be shared with you. Thank you so much.
Thank you so much, sir. Appreciate your additional observations there. We also have one last person that we'd like to bring in a bit ad hoc, but nonetheless, Mr. Wilson Adeu. He will be speaking in Portuguese, so if the technical people could also elevate him to the panel, I would appreciate that. Mr. Adeu is the head of the Human Rights Center of Angola's Catholic University, and he has been an implementing partner with the United Nations Development Program for free legal aid to survivors of gender-based violence and domestic violence. So, Mr. Adeu, if you are there, the floor is yours. Mr. Adeu, are you there? No? Okay. I don't know whether he has dropped out or not, but let me use the moderator's prerogative here, if I may. I'd like to start and kick off the discussion a little bit, both between the panelists and also amongst all the participants from around the world. I thought one of the issues that has come out was in essence a little bit about technology. We did touch upon that. And I was wondering from the panelists, for those of you that are in countries where you had remote hearings or used technology to try to overcome some of the issues of COVID-19, did you find that the legislative framework was in place to accommodate those changes? Or was there a need to very quickly address those legislative framework deficiencies in order to be able to put in place technological solutions to the problems faced or created by the pandemic? The second general point I'd like to put out there is also in the panelists' experience, especially the panelists we have that are working directly with vulnerable groups, did you notice any special effects on women and children in particular? And what were some of those issues that women and children in your jurisdictions faced? And have you been able to address that? Are there still outstanding or latent issues that you are working on to try to ensure that women and children in particular, or for that matter, I suppose even perhaps various ethnic groups or indigenous groups, are being able to access justice during the pandemic? Are any of the panelists willing to take that one on to start with?
Okay, maybe I could just say a thing or two on that. Yeah, for my country, Nigeria, about remote hearing, it's not something very common here. So it had a lot of challenges. We experienced quite a number of challenges in the process. During the lockdown, we had information coming to the prison facilities and lawyers coming into the prison to get judgments delivered on inmates that are in custody. So they came with computers with internet facility. So we noticed sometimes the internet facilities were not really efficient. So there were so many hiccups here and there. So it wasn't really convenient, even though for some jurisdictions it was quite efficient. In most other jurisdictions, it was not really efficient. So that was a huge challenge. I can't really say it was well managed. Then for women and children, I cover more the female prison, now Correctional Service Center in my state, Lagos, Nigeria. So there we noticed that there's this family link, you know, the inmates don't have access to their families, and because no visitors were allowed, so it impacted them in that sense. Because for those that have kids, the children grow to a particular age, you have to send them home. You don't keep them in the correctional center with the moms, with their mothers. So before now, they were having access to visitors and they were able to see their kids and bond with their children. But with the pandemic, no visitors allowed. Those bondings were not in place, so it affected some of them psychologically. But however, now things are relaxing a bit, so it's not as intense as it was before now. So I believe more has to be done, more effort needs to be put in place to enhance the ICT capacity in criminal justice administration of many countries, especially in Africa. Thank you.
Thank you so much. Ms. Tralmaka, I don't know if you want to come in on that one at all also, since it's an area that you're both working in and studying. Your perspective might be quite interesting on this.
Yes, thank you. I will address the first part of your question about the legislative framework. It differed from state to state. We heard of countries where there were emergency laws passed to enable remote hearings and to allow the courts to regulate themselves more freely in that situation. There were also states where the instructions came from within the judicial system for judges to get Skype or to get these technologies that would facilitate. But of course, one main conclusion is that the legislation, if it was in place, it was adopted in haste. So, and also what was worrying us once the initial stages of the pandemic went on into the beginning of summer, there was talk of making these changes permanent. And I think that this is something that we need to be cautious. Like if we want to keep some of those emergency measures that were introduced, we need much more better quality legislative work done. We need facts. We need impact assessment before we can go and adopt permanent restrictions to defendants' rights. When we talk about juveniles and women, we didn't focus on those two groups in particular, but what was also prominent in the beginning, the juveniles in at least a couple of countries were excluded from the types of defendants, categories of defendants where remote hearings could be conducted. So they were out of that. But again, as the pandemic kept going on and the backlog was getting bigger, states included juvenile defendants into the possibility of having remote hearings. We have not heard on specific impact, but that would be very interesting to know how defendants, how juvenile defendants experience remote proceedings. That was not very helpful on the second part, but.
No, thank you very much. Gandanfar, I'm going to turn it over to you in just a moment, but I'm going to take moderator's prerogative here. And I also realized that because of our technological glitches at the beginning, I was quite nervous at the start. And so I actually forgot to introduce myself, quite the faux pas there. But I mean, I'm currently managing a joint One UN program in Palestine. We also work on a significant amount of access to justice and legal aid issues. And one of the interesting things that I noticed here in Palestine was that we actually have been working for a number of years on the technological advances to make remote hearings possible, but we also did not have the legal framework in place. And so, in fact, what I've been hearing from other colleagues around the world and in various webinars that I've been in, that it tends to actually be the other way around, that either legislation is there to allow remote hearings in some way, or you have a problem of both the technology not being there and the legislation not being there. And so what was interesting in the Palestine context is that we actually have the technology, but we don't have the legal framework. And the legal framework, the president was reluctant to adopt any legislation to enable that legal framework because a state of emergency was declared. And so he was quite reluctant to adopt any legislation during the emergency powers that he has. So we ended up in a bit of an odd situation, I think, from most countries. But Gandhanfar, please, if you have anything you'd like to add on that from your perspective.
شكرا جزيلا. في الحقيقة يعني ابتداء مستر كريس يعني أريد أن أشكرك على الجهد الذي تقوم به في فلسطين. فيما يتعلق بموضوع الجلسات عن بعد، لها أهمية كبيرة في فلسطين تحديداً. ابتداء الواقع المتواجد في فلسطين حالياً وصعوبة التنقل والتنسيق بين المحافظات يجعل من الجلسات تتأجل بدون مبرر، فلذلك أعتقد أن ذلك يشكل عدالة متأخرة وهو ما يشكل ظلم. لذلك أعتقد أننا يجب أن نسعى بحال من الأحوال إلى الحصول على الجلسات عن بعد عن طريق في الطرق الإلكترونية. هذا من ناحية الجلسات عن بعد. بالإضافة ما يتعلق بالأطفال هون في فلسطين وأثناء تواجد وأثناء مواجهة جائحة كورونا، في الحقيقة أطراف العدالة بذلوا مجهودات كبيرة. نحن كمؤسسات مجتمع مدني والمؤسسة القانونية الدولية كما ذكرت سطرنا كتب عديدة حتى نضمن إخلاء سبيل الأطفال قدر الإمكان من مراكز الاحتجاز، وأطراف العدالة من نيابة، من مراكز تأهيل، من محاكم، من كافة الأطراف عملوا على هذا الشأن. ولكن كان لابد أن نركز، ويجب أن نركز أيضا أن الأطفال خصوصية معينة. ملاحقة الأطفال على مخالفة قوانين الطوارئ كانت مشكلة كبيرة، فلذلك حاولنا ولا زلنا نحاول أن ننشر ونرفع الوعي في اتجاه عدم ملاحقة الأطفال على أشياء أعتقد أن دماغهم بطريقة أو بأخرى ونضج الدماغ لدى الأطفال يدفعهم لعمل ذلك. فهذه النقطة التي كنت أود أن نركز عليها فيما يتعلق بالأطفال. إضافة لذلك أعتقد أنه هناك مجموعة من القوانين اللي حاليا في إطار تشريع في فلسطين، وفي حركة تشريعية جديدة وتعديلات من قبل فخامة الرئيس من قبل أطراف العدالة، وإحنا كمان كمجتمع مدني بنشتغل على المناصرة في هذا الشأن. فلذلك أعتقد أننا يجب أن نستغل هذه الفرصة في إظهار الاحتياجات اللي موجودة في فلسطين، من ضمنها النقطة التي ذكرتها وهي الاستماع إلى الجلسات عن بعد. شكراً.
Thank you very much, Gandhanfar. We have we have a few questions in the Q&A. To our IT technical assistants, I'm wondering if you could try to elevate Deselgen Kebede Kaza, who has asked a couple of questions, and perhaps they've raised their hand. If you might be able to elevate them, I believe they are speaking in English for the translators. And apologies, I'm not sure if it's Mr. or Ms. Kaza, but if you're there and you would like to speak, the floor is yours.
Okay, hello.
Excellent. Thank you. Floor is yours, sir.
Okay, thank you, Mr. David. My name is Mr. Desaleng. I'm participating from Ethiopia, and I'm working as the head of the Office of the Public Defenders of Ethiopia. You might be aware that Ethiopia is one of the countries that practice federalism. So there is a jurisdiction for the federal courts and a jurisdiction for the state courts. So my office has defense attorneys that represent the case that fall under the jurisdiction of the federal courts. So I am a bit interested to contribute on the legislative framework with regard to the utilization of technology during the COVID-19 pandemic and before that as well, and also the issue related to the how we do handle the case of children and the women during the COVID-19 pandemic and before that. As far as the first issue that you have raised is concerned, in Ethiopia, practically speaking, there is no clearly written legal framework that obliges the courts to use the remote hearing platform, but using the concept of access to justice as fundamental issue. The judiciary at the federal level is trying its level best to conduct e-litigation, but it's very limited in practice. So, for instance, the Federal Supreme Court of Ethiopia is using the e-litigation platform to hearing the appeal cases and also to hear the cassation hearings. But during the COVID pandemic, how do we handle as the public defenders is the courts use to the e-litigation platforms to pass the decisions, both the sentencing decisions and all the court decisions. But it has become a challenge for us because the technology is a bit somehow unfamiliar to our clients who are indigent and who have no access and who have also no know-how as well. So it also has become a challenge for us because it might also affect the financial component when we talk about the issue of access to justice. So it requires the public defense attorneys to physically access the indigent accused person, whether that accused person is juvenile or adult, before the hearing. So the hearing might be conducted electronically via e-litigation platform, but in advance, it might require physical access and also making the consulting and also making the facilitate the precondition facilitation activities. But this is very difficult. This has become very difficult for us, and we have presented this issue to our court officials, and they are willing, but these are still challenges in Ethiopia. With regard to the issue of children's rights, can I continue, please?
Very briefly, please, because we do have a few other questions and we have about 10 minutes left before we need to wrap up.
Okay, thank you, sir. The issue of children in Ethiopia is actually the detention is taken as a last resort. It's a last measure, and it's not advised, but there are other challenges, age determination issues. Who is juvenile? And either practical document that clearly shows that an accused person who is indigent is really juvenile or not. So these are some of the challenges that we have been facing. And there are also facility issues because there is no rehabilitation center, appropriate rehabilitation center in Ethiopia. So these are some of the challenges that we have been facing, but despite the challenges, we have been trying our level best to address all the issues and to maintain that the right of the indigent persons are protected and the appropriate and the competent defense attorneys are being represented at the court trials. Thank you.
Thank you so much, sir, for that. I understand Rachel wanted to take the floor briefly, and then we have two other questions that we'll come back to. And as I say, we have just about 10 minutes left before we need to wrap up. So if there are any other questions that you'd like to put in the question and answer section, we will try to get those questions to our panelists and give them the opportunity. So Rachel, the floor is yours. Okay, sorry, misunderstanding there. Let me go then to the two. It's a learning experience for us all. Let me go then to two of the questions, which are actually aimed a little bit more at Ms. Tralmaka, and again, your study. One of the questions that's come in is does the study cover any aspects of psychological effects of virtual trials on defendants? And a second question that's come in from Anat Horowitz is, were there challenges in respect to remote hearings made in European courts? And if so, what were the court's responses to these challenges? The floor is yours.
Yes, thank you. Remote hearings is a very hot topic right now. On the first issue, I can we have not studied it ourselves, but I can maybe refer you to a question to a study that was recently made by UK Equality Commission on vulnerable defendants specifically, and there was also one that recently came out on a testing tool for court bookings. I can't tell you the name, but I'll try to find out and that study and share a link if I can manage during this time. But those ones contain questionnaires and interviews, well, the conclusions drawn from the interviews with defendants, and they do touch upon the experience of defendants, and the main conclusion is that especially if appearing without a lawyer, that's usually the case, defendants feel more isolated. They feel either more anxious or more passive, depending, and more confused, which also kind of does make it very easy to follow the trials and especially to intervene or to give any kind of meaningful instructions to their lawyers when there is such an opportunity. So predominantly we've heard from what we have the information, it's mostly negative effect. On the challenges to the courts, it would be very interesting for us to also know. We haven't received any information at this point. We have been working with lawyers. We have created a template for granting the access to confidential place to talk with lawyers and clients. We have these template pleadings, but we would be happy to hear whether they have been used to successful result or even unsuccessful. But I think at this point, probably if the issues are raised, they're in appeals stage. But I'm not aware of a precise, I can't refer you to a judgment at this point.
Wonderful, thank you for that. I'm seeing that there are a few additional questions. One is more of a comment, which it's been posted, the translation of it has been posted in the chat from Judge Assad, who is Secretary of the High Judicial Council here in Palestine. I'll just draw your attention to what he was discussing there, and also just noting that remote trials and electronic notification is something that they're hoping to work more on. Certainly in the context of the ongoing pandemic, it's clear that there's no panacea for the pandemic, and so and I think one of the other speakers brought it up. We're looking for quick solutions to solve the problem, but often once these solutions are brought in, they don't go away. So we also have to try to think very carefully if these are solutions that we want in the longer term, because the chances of them being repealed are fairly slim. I think, let's see, there is one more question again. It's a bit skewed to fair trial here. Most of the questions are coming in relation to your study, but I think what I'll do at this moment is maybe I'll try to give one of the other presenters another opportunity. Ms. Buteau, I don't know, would you like to come back in with any comments on some of the questions that have been raised?
Oui, alors, merci. Merci beaucoup. Je pense que en écoutant surtout l'expérience des audiences virtuelles, ça, il faudrait, comme vous venez de le dire, nous aimerions bien trouver une solution surtout et favoriser l'accès à la justice. Mais il faudrait aussi voir est-ce que il y a les moyens, parce que quand on parle de l'Internet, ça nous renvoie aux moyens. Est-ce qu'il y a des moyens qui pourront permettre à tous les acteurs, toutes les parties au procès de se connecter et puis aussi participer au procès? Ça, c'est aussi notre inquiétude par rapport. Mais c'est une belle initiative, mais il faudrait voir aussi les conséquences qui pouvaient en venir.
Okay, thank you very much for that. Yes, I mean, I think there are certainly the unintended consequences which we all need to be very mindful of. And I do think that in many of the countries that we've had this discussion in relation to, obviously there's the technological issues. It's not just a question of internet, electricity, things like this, but it's also, you know, do the courts have the computers? Do they have the VTC equipment to be able to do this? In some cases, you know, there are obviously some benefits to this. Again, one of the issues that we had in Palestine and Gandanfar, I don't know if you want to just pick up on this very, very quickly. But obviously, one of the issues that we had is that you have a unique situation in Palestine with it being occupied. And so sometimes even the transfer of prisoners between detention facilities and courts can be a challenge because that requires the permission of the Israeli authorities. And so in some ways, having this technology would even overcome some of the other problems that Palestine faces in relation to its criminal justice system. But nonetheless, I think as Ms. Chalmaka has certainly pointed out, the potential psychological effects or the true effects of access to justice could be infringed. So Gandanfar, I don't know, do you have any thoughts on that in relation to Palestine?
عفوا ممكن بالترجمة شوي ما وصلنا السؤال بس هو If you can just repeat the question.
I was just noting the fact that the particular problems of occupation in Palestine and movement of prisoners between detention centers and courts. And I was saying that in some ways, the possible solution, some of the solutions for the pandemic would also in fact be solutions to some of the problems that the Palestinian justice system has in overall in its criminal justice system. So I was just asking if you had any thoughts on that or any other sort of thoughts, basically, yes.
صحيح، أعتقد أنها راح تكون حل جذري فيما يتعلق بالتنسيق بين المحافظة والأخرى. السياسة حاليا أو طريقة العمل حاليا إذا كان في جلسة في محكمة رام الله والسجين أو الموقوف موجود في سجن نابلس، نحن بحاجة لتنسيق منذ يعني أسبوعين على الأقل، ممكن قبل موعد الجلسة، حتى يتم تنسيق له للانتقال إلى محكمة رام الله. هذا من جهة. من جهة أخرى كنا قد تحدثنا عن الفئات المهمشة مثل النساء لا يوجد مراكز احتجاز في كافة مدن الضفة الغربية للنساء، لذلك إذا كان هناك امرأة من نابلس، من مدينة نابلس موقوفة، يتم توقيفها في مركز إصلاح وتأهيل جنين. لذلك تحديدا مع النساء سيتم تأجيل الجلسات أشهر فقط لغايات التنسيق لحضور الجلسة. فأعتقد أنه الحل الإلكتروني والجلسة عبر وسائل التواصل الإلكترونية أعتقد أنها ستحل أزمة كبيرة. بالإضافة لذلك من جهة أخرى، إذا تحدثنا عن الأطفال الأحداث، محاكمنا في فلسطين إلى الآن الموارد لا تمكننا من أن يكون هناك محاكم مستقلة بمباني مستقلة للأحداث، فذلك فيه مخالفة بطريقة أو بأخرى لقانون الأحداث. فكيف يمكن للأحداث أن يذهبوا إلى الجلسات في ظل وجود البالغين والناس؟ هذا مع العلم أنه يجب أن تكون سرية جلسات الأحداث، ويجب أن يتم إبعادهم قدر الإمكان عن الاختلاط مع الناس. فهذا ينقلنا إلى نقطة أخرى، أن هذه الإجراءات ستؤثر سلبيا على نفسية الطفل، وهذا ما أشرت له في العرض الخاص بي عندما قلت أن الإجراءات ونظام العدالة بطريقة أو بأخرى قد يخلف صدمات وآثار سلبية على الطفل نفسه. فلذلك أعتقد أنه يجب الدفع من أنظمة العدالة ومن مؤسسات المجتمع المدني باتجاه تبني قانون أو نظام قانوني أو تجربة حتى أن نقوم بعقد هذه الجلسات بطريقة إلكترونية عن بعد. وأعتقد أنه في الملاحظات في المحادثة الأمين العام لمجلس القضاء الأعلى أشار بأنهم يسعوا بها في مجلس القضاء الأعلى، يسعوا باتجاه تبني تشريعات من هذا الشأن. فأعتقد إذا تلاقت الإرادات بين الجميع، أعتقد أننا يجب أن نبدأ بخطوات عملية حتى نسعى لتحقيقها بأسرع وقت ممكن.
Thank you so much. We're coming to the end of our time together. I think we've had quite an interesting discussion, despite the technological issues that always come up with these webinars. So my job as moderator at the moment is to try to sum up a little bit of a couple main points that we've hit upon. Also, for those of you that are familiar with these conferences, there is essentially a declaration that takes place, a sort of call to action that usually completes the conference. And so it's also, when it would be in person, it's much easier to have these discussions about what should be included in this final conference document. Unfortunately, because of the technology, we're not really able to have that sort of interaction. But what I think I will kind of do, one or two points really to me came out loud and clear, and I think they certainly warrant consideration by the drafters of the final document to consider being placed in such. And one of them is on the remote hearings, and that there are really two sides to weigh in on how challenging, successful they are in actually solving the situation of a lack of physical access. The second one is that clearly there needs to be much more work done on both the frameworks and ITC services, so that there's more awareness and facilitation of services that should take place. I think there's even perhaps a larger question about whether remote trials, we've only talked about remote hearings, but what about even remote trials as a whole, to what extent is that really providing access to justice? To what extent is that an equality of arms, where both the prosecution and the defense are really on equal footing if the defendant is not really capable of taking part in a actual and meaningful way in the proceedings simply because of the technology. So I think those are big questions for us that perhaps deserve to be in that final document, and that more work should be done on. At this point, it's also my job to thank all the panelists wholeheartedly, again, for overcoming both translation, language issues, technology, low bandwidth, all these things. I think we've had a really fruitful discussion, and I deeply appreciate all the work that they've put into preparing for this, and the patience that they've had in dealing with the logistics issues. So thank you to all the panelists. And of course, this conference couldn't have taken place without all the work behind the scenes. And I'm not going to mention people by name because I will certainly leave someone out and offend somebody. But I will just generally say ILF, UNDP, UNODC, and of course, our colleagues in Brazil, the various offices in Brazil that have done so much work and spent so much time putting this conference together over the past months. We thank you very much for giving, at one point we had over 137 people participating from around the world. So thank you to all of you for doing that. And again, thanks to everyone for participating. And I hope you maintain the contacts you've made here today in the chat, that you have found it fruitful. And I look forward to hopefully seeing some of you and working with you again in the future. Thank you very much.